Hi, I'm Janice Yates, HR Advisor at the Hawaii Employers Council.
As an employer, having an unpaid intern in the workplace sounds like a great opportunity. However, the laws regarding whether an individual can be an intern or must receive compensation for their time can be tricky. This is especially true because in January of this year, the U.S. Department of Labor recently revised their guidelines on when an individual can be treated as an intern versus an employee. Based on recent court cases, the DOL has adopted a primary beneficiary test to determine whether an individual can be an unpaid intern. Under this test, if the employer is the primary beneficiary from the relationship, the individual must be paid. On the other hand, if the intern primarily benefits from the working relationship, the intern can be unpaid. The primary beneficiary test involves 7 factors. No single factor is determinative. Rather, each situation must be evaluated on a case-by-case basis in consideration of all 7 factors. The 7 factors are as follows. Number 1, the extent to which the intern and the employer clearly understand that there is no expectation of compensation. Any promise of compensation, express or implied, suggests that the intern is an employee and vice versa. Secondly, the extent to which the internship provides training that would be similar to that which would be given in an educational environment, including the clinical and other hands-on training provided by educational institutions. Number 3, the extent to which the internship is tied to the intern's formal education program by integrated coursework or the receipt of academic credit. Number 4, the extent to which the internship accommodates the intern's academic commitments by corresponding to the academic calendar. Number 5, the extent to which the internship's duration is limited to the period of which the intern provides the intern with beneficial training. Number 6, the extent to which the intern's work complements rather than displaces the work of paid employees while providing significant educational benefits to the intern. Number 7, the extent to which the intern and the employer understand that the internship is conducted without entitlement to a paid job at the conclusion of the internship. According to the DOL, these 7 factors provide employers with increased flexibility to determine whether an individual can be an unpaid intern. In other words, failing to satisfy all 7 factors doesn't necessarily mean an individual cannot be treated as an intern. Instead, as I mentioned earlier, all 7 factors must be weighed, balanced, and considered under totality of circumstances. In other words, the student should be the one who primarily benefits from the internship when considering all 7 of these factors.
If you're not sure whether the individual qualifies as an unpaid intern, we strongly recommend that you consult with an experienced HR consultant or an employment attorney. Thank you for watching and have a great summer.